most jurisdictions, and there's probably about 140 separate local jurisdictions which have come up with their own eviction protection ordinances. They all tend to say the same thing, though some of them do vary. Most of them have the provisions where if in fact the tenant's inability to pay the rent is causally connected to the COVID-19 virus pandemic, then in that situation, the tenant is allowed to forbear from paying the rent. Most jurisdictions would state that it would be 6 months to pay back rent. Jurisdictions like Los Angeles or unincorporated area of the county and a few others are giving the tenant 1 year to pay back rent. So if in fact, for example, you had a tenant who was maybe worked in the restaurant industry and the restaurant was closed and he legitimately could not pay April's rent, the way the statute is written is that he would be able to forbear paying that rent for that month for the months of April, and let's pretend it goes into May, and then that would allow him to repay that lost rent in 1 year for Los Angeles and unincorporated areas of Los Angeles County, or for other jurisdictions, generally it's 6 months to repay the rent. We all know that at the end of 1 year period or at the end of a 6 month period, the chances that the landlord will ever be able to recoup this lost rent is probably slim to none. But unfortunately, that's where we find ourselves. Now, once the pandemic is over, of course, and let's pretend that the pandemic is over in May 31st, June 1st, then at that point, of course, tenants will be obligated to pay that rent as it becomes due, and the landlord can pursue his remedies through the court systems. So that's generally what the different municipalities are stating, that if in fact the breach of the contract, and it doesn't just have to be rent, it could be for unauthorized occupants, it could be for pets, but if it's causally connected to the COVID, then the tenant gets a bye and that part of the contract is waived. And again, for the issue of rent, the tenant wouldn't have to pay the rent for those months in questions for the period of when that pandemic occurred. So again, usually that would be March, April, and May, and depending however long it lasts. The interesting issue would be, what if you had a tenant that didn't pay rent, for example, for December, January, and February? Would you be able to go forward with those cases, since easily it's not causally connected to the pandemic? Or, for example, let's take the scenario where you have a tenant who refuses to pay you rent for March and April and May, but that tenant was on a pension and also on Social Security. We're doing one of those cases right now. That situation wouldn't prevent that tenant from paying the rent. It's not causally connected to the pandemic, and as such, landlords should be able to proceed forward with a 3-day notice to pay rent or quit and proceed forward with the eviction. Because again, all these statutes, local statutes, are tied in to the pandemic. And if it's not causally connected, then of course you can go forward with it. Now, the governor, of course, did slow down all cases again, but it had to be causally connected to the pandemic. So the first thing you want to do as landlords is you do want to, anytime a tenant is telling you that they can't pay, you want to inquire as to the tenant as to why you're not paying the rent. And if they just say, well, I'm not telling you, then technically you can go forward with it. Or let's pretend a situation occurs where you have a tenant that legitimately lost his job. I'm doing a cosmetic surgeon in Beverly Hills who legitimately is not doing business. But the truth of the matter is this cosmetic surgery has $500,000 in a bank account, if not more. Does that mean that that person cannot pay his rent? And the answer is, of course, that person can. really what you have is a tenant who wants to preserve his capital over the capital of the landlord who wants to get his rent. So again, it has to be an inability not to pay the rent due to the pandemic which has occurred. So again, you need to inquire of your tenants, put it in writing to them, ask them in writing whether in fact what is happening now that you don't. You can ask for bank accounts, you can ask for letters from their employers that have been terminated. Some jurisdictions do require that the tenant respond. I know Beverly Hills State, excuse me, West Hollywood states that you have to respond within 30 days. Santa Monica has a separate one. I know the city of Los Angeles states specifically, you do not have to respond as to specific proof. You just merely have to tell the landlord, I'm not paying and it's COVID related, and then that would be sufficient for the tenant not to pay the rent. And at that point in time, you can't proceed with an eviction. But again, if it is not causally connected, then at that point in time, you have every right to file a notice to pay rent or quit and proceed forward with an eviction action until we turn our attentions to what the Judicial Council did in an emergency rule dated April 6, 2020. What is the Judicial Council? God only knows. It's administered by the Supreme Court for the state of California, and its function is to deal with the clear and efficient running of the court system. I question their ability to make rules that change the laws, but rules that change the laws is what they did. So what did the Judicial Council, that's the third arm of what we're talking about after the governor's order, after all these local jurisdictions, what did the, now I'm getting some background noise from somebody, please mute your mic. But in that situation, the Judicial Council did, I wish that person would be quiet, please. Please mute yourself, or if the monitor could mute that person, I'd appreciate that. But the Judicial Council stated that regardless of the reason,
Bobby Macias line, please mute.
Bobby Macias is muted. He's the one that's coming.
Everybody, the Judicial Council states that an unlawful detainer case can be filed, but they will not issue a summons. A summons is always attached to every lawsuit, and that's what summons the tenant to court. If you don't have a summons issued on a lawsuit, then there is no obligation on the part of the tenant to answer the lawsuit, so the case is stalled. So part of what the Judicial Council's emergency rule was as of April 6th was that lawsuits can be filed, but you cannot issue a summons if you're a court, unless it's dealt with health and safety issue. The other thing that the Judicial Council talked about insofar as income property owners is that if you already had a lawsuit filed, if you already had a summons issued and you already served your tenant with that and you were ready to take a default, the Judicial Council rules now state that the courts cannot issue a default so that I could get a judgment on a case until such time as the pandemic is declared over. And I'll get to that in a moment. The last thing that there's two more things they did was, if the tenant has answered the lawsuit, they have now delayed all trial dates for at least 60 days past April 6th that a trial date can't be given. And last but not least, if I have a writ of possession, which I would already be given over to a sheriff's office to do the lockout. In other words, I already have a judgment and the case has already been adjudicated and the tenant has already lost the case. According to the Judicial Council's rule, I cannot issue a writ of possession to deliver that to the sheriff's office. Now, these rules are in place incredulously until the governor of California declares that the pandemic is over, and then, believe it or not, add another 90 days to the equation. So therefore, in the case where I have filed a lawsuit, but the court has not issued a summons, I would have to first wait for the governor to declare that the matter is over, and then wait for another 90 days. This is insanity. The same thing is true with a default. I'm ready to file a default in so many of my cases. The tenant hasn't answered. There is no argument. I cannot file a default that will be accepted with the court until, number one, the governor declares that the pandemic is over, and then add another 90 days. The time period for adding another 90 days is insanity and is really a situation unlike ever seen before, and literally causing landlords to lose their buildings. I mean, that's just what it's going to be. Let's do the math, everybody. And you don't need to take out a pencil to figure this out, but let's pretend that you're in a jurisdiction like Los Angeles, where the tenant claims that the rent was not paid due to the pandemic. So the tenant doesn't pay the March rent, the April's rent. Of course, landlords would be prohibited from serving a 3-day notice and starting a lawsuit because it's causally connected to the pandemic. And of course, now we're going to move into May. And let's pretend that the pandemic is now over as of May 31st. The governor issues the order. And we now know, of course, that the tenant will owe June's rent. Well, what if the tenant doesn't pay the June's rent? We know that in the city of Los Angeles, it would be 1 year to pay the March, April, and May's rent. 1 year that you're going to have to wait for your money. Good luck on getting it after 1 year, but at least it's deferred for 1 year. But for the June's rent, the landlord could technically serve a 3-day notice, but based on the Judicial Council's emergency rule, they will not issue a summons for 3 more months, which means that any tenant will have carte blanche to not only pay the March and the April and the May's rent, but they don't have to pay the June, July, and the August rent. So now landlords have gone 6 months before they can finally start to enforce their rent, their rights to their rent. And that's only for the last 3 months from June, July, and August. So now comes September, the big day. And again, we're under the assumption that the governor, in our example here, declared that the emergency rule was over as of June 1st. So now comes the big day, September 1. Now I have the right to at least file an eviction case based on rent that wasn't paid for just June, July, and August. But if I filed that lawsuit, guess what? How many other landlords are going to be filing that lawsuit at that period of time? You're going to have tens of thousands of landlords, this pent-up demand to file lawsuits based on these tenants who are not going to come up with the rent. Why should they? They didn't have to come with March, April, and May, and they're certainly not going to pay the June, July, and the August or September. So we're going to have a plethora of landlords who are going to be filing lawsuits come September 1. At that point in time, do you think our judicial system is going to be able to handle the load of cases that are coming? It is going to be so crazy busy at that point in time where the court system really will become overburdened and will break down. I would predict that at the very minimum, it's going to take at least 6 months from September 1 to go forward and get your case finally heard and adjudicated. So if you do the math, then it's pretty simple. You didn't get your rent for the first 6 months from March through August, and it's going to take another 6 months. Most landlords are going to be in a situation where they can lose their buildings. Now, during this 1 year period, what's going to happen? If the tenant complains that something is wrong, landlords are still duty bound to fix it. Doesn't matter if it's an inexpensive repair or an expensive repair. This is on the backdrop of no rents, no proceeds coming in. Landlord has an absolute obligation. Landlord also has an obligation to keep the utilities going, to keep the trash service going, to keep his insurance going. And what about those property taxes? Have they been waived by any municipality? And the answer, any county, and the answer is no. So we have to go through all the expense of our property taxes, repairs of our buildings, all of our expenses, and we could be fined. I mean, they can literally take away our buildings for us if we don't make repairs. Yet we have no income coming in on this. And then we get to the point of our lenders. Many, obviously, landlords have mortgages, if not most. And how are they going to support their mortgage for 1 year without payments coming in? This was such an ill-conceived notion on the part of the Judicial Council, having no care for the result that it would have for property owners. All it was a feel-good motion to assist tenants with no thought process as to what it was going to do for other members of our society. Now, if people really want to help tenants, then it's the government's job to step in there. And I've been suggesting, in terms with the Apartment Owners Association, which if you go to their website, you can sign a petition, that there should be rent vouchers so that the tenants can pay their rent. This shouldn't be on the backs of landlords to be forced to become financial institutions, forced to give 1 year loans. And then, quite frankly, those loans are going to turn bad because no tenant's going to pay after that year. So we're in a situation where landlords truly are going to lose their buildings based on the fact that they have to keep up their buildings, they have to pay their property taxes, they have to pay their mortgage payments. Where is this money coming? Okay, everybody believes that all we are dealing with are rich landlords, but I'm sure from the now 412 participants that are in this webinar, that we all know that most of us are small mom and pop owners. Most of my clients own buildings from maybe 4 to 10 units, and in a lot of cases, they live in their own units. They don't have this money. So we see our politicians and some entity called the Judicial Council just making up laws as it goes along that are literally going to be putting landlords out of business. So what can we do? Well, I've come up with a plan that I think will have some relief, not 100% believe, because there is nothing. The only way for them to be relief would be for the Judicial Council to waive their requirements and allow us to proceed forward with lawsuits. And again, these lawsuits could be for any reason, not for rent, but they don't really make a distinction unless it's health and safety. So unless you have a tenant that's really creating a nuisance, you have no basis of going forward with this. Take, for example, for those real estate brokers out there, where you've issued a 60-day notice to a tenant having nothing to do with rent on a single-family home. Why? Because the house is sold and the new owner wants to move in, and the tenant flatly refuses. Maybe the tenant hasn't lost his job. But again, in those situations, you have no way of asking the tenant to move, no way of enforcing it. It's like putting up a sign on the freeway that says the speed limit, the strict speed limit is 65 miles per hour. And then there's a little sign underneath that says, but we're not enforcing it. What's the point? So what can we do? Well, I've come up with an idea that if you can determine that the reason why the tenant is not paying rent has nothing to do with the COVID-19 epidemic, then I have a plan. So this is what my plan is. And that is, assuming you can approve that, either the tenant hasn't communicated to you or the tenant hasn't lost their job. Maybe they're in the medical profession, so you know they're working every day. Or potentially you have a tenant who's on a pension, as I stated in one of my examples. In those situations, I would highly encourage you to immediately serve a 3-day notice. Nothing prevents you from doing so in any local jurisdiction or by that judicial council's emergency rules. And then what I would do is I would file an unlawful detainer action. Now, we know by the judicial council rules that the courts will not issue a summons. So what's the point of filing an unlawful detainer action at this time when you know that you cannot proceed forward with the eviction? And I will tell you the reason why you should and what we've been doing for our clients. And that is that we file the lawsuit, no summons is issued, and then I will simply mail that lawsuit to the tenant with an accompanying letter. That accompanying letter will tell the tenant that, number one, rent will never be forgiven. At any point, we might allow it to be held until the 6-month or 1-year period, but you are going to have to pay that rent at one point in time. It also encourages the tenant that since they have been sued and the lawsuit's not going away, even though it might be delayed, to contact your landlord and see if you can make a deal. For the tenants that we've done this, we've had a pretty good success that tenants, when they're facing a lawsuit, which is intimidating, even though I can't go forward with it, they generally do call their landlord and do make an agreement. For some landlords, maybe it makes sense to waive 25% of the rent if you can get your rent now, as opposed to waiting 6 months to 1 year for your rent. So there's all types of deals. You can enter into a deferment contract with your tenant, which would then allow the tenant to pay you quicker than 6 months to 1 year, which is certainly legal if they enter into this deferment contract. But at least you're going to start a dialogue with the tenant, and the tenant's going to know that they have been sued and that it's to the interests of the benefit interests to both parties to try to settle the case. But what happens if your tenant doesn't make any attempt to contact you? So you have this lawsuit filed, but quite frankly, there's nothing that you can do with it. Well, we found that in some small percentage of cases, tenants, when they're served with a lawsuit, do answer the lawsuit because they see a lawsuit, so they're going to go down to the court and they're going to file an answer. For those cases, I can request a trial. My trial will be delayed 60 days, but great. 60 days seems pretty good to me now, because now I can actually get a trial date, and I will be one of the first ones to be able to go to court and eventually adjudicate this matter and eventually get a judgment against this tenant, and of course enforce it through the sheriff's office. So that's a second advantage for filing these lawsuits right now. But there's probably the third one, which is the most important. If your tenant doesn't contact you to make a settlement, if your tenant doesn't file an answer, you are stuck waiting until the governor declares that the pandemic emergency is over, and then let's tack on another 90 days. In my example, if he does declare it's over as of June 1st, then we wouldn't be able to file our first lawsuit until September 1st. And at that point in time, you can understand that the courts will be overburdened to likes that I've never seen in my 43 years of practice. And again, to get into the court system and finally obtain a judgment and finally get that over to the sheriff's office, that will be a 6-month period. But you see, the way it works with court systems is that the person who's filed first has more priority than the person who's filed second. We are filing a ton of unlawful detainers now, and we're just waiting. We're waiting for the 3 months to be over after the pandemic is declared over by the governor. Based on that, my case numbers will be much lower than those landlords who are first filing lawsuits come September 1. And on that basis, even though the floodgates will be open and every landlord under the sun will be filing an eviction lawsuit to get rid of their tenant, our lawsuits will go quicker. So I'm encouraging landlords that, again, this only works on those cases where the tenant has not paid the rent and it's not due to the causation of the pandemic. But if it's not, and there are so many cases that aren't, then we have the right to file now. And again, we might have some luck that the case is settled, or we might get a trial date, but at the very minimum, if nothing occurs, I have a higher priority than everybody else. So it makes sense for everybody in those situations to get your cases filed. So we're seeing a situation where, again, tenants, when they get served with a lawsuit, even though they're not legally served, do feel intimidated with regard to going forward with the case and giving us a much better opportunity. Again, I would encourage everybody to go to the AOAUSA.com and sign that petition, where it doesn't put the burdens on landlords that it does put the burdens on the politicians to make for rent vouchers. Also, if anybody needs my information, on my website is evict123.com. That's EVICT123.com. I'm going to open it up to some questions now, if anybody had written in. I don't know if Anthony is on the phone. Are you, Anthony?
Yeah, I'm back on here. So yeah, I'm going to address a couple questions that I can see here. There's a lot of comments, but I'm going to address some of the questions. First one is, what legal forms must be sent by April 30th to all tenants in California, specifically Los Angeles?
Well, if you go to the Los Angeles Rent Stabilization website, and there is a form that's just for residential landlords in the city of Los Angeles, that has to be served on your each and every tenant, whether they're paying rent or they're not. I am, as soon as I hang up from this, I'm going to post that on my website, so it'll be easier to find at evict123.com. There'll be a link to that. I have been sending that out to my clients, but I will have it prominently displayed on my website, so you'll be able to go over there. But that needs to be sent to every Los Angeles owner. I know that Santa Monica also has instituted a specific notice, so any Santa Monica owners out there, you should go to the Santa Monica Rent Control website, and that needs to be served on all of your tenants within 30 days.
Okay, good. Next question. What law allows the Judicial Council to make? What law allows the Judicial Council to make any laws? Oh, forget it. That's a comment. Sorry about that. Can we file in federal?
Good comment, by the way.
Can we file in federal court as a due process violation, depriving landlords of income and property?
I'm not a federal court expert. I don't practice federal law or constitutional law. Generally speaking, when you're dealing with, quote, health and safety, which is the way they're tying these orders and edicts and rules and ordinances, then generally that the state's decision for health and safety reasons are going to be upheld. So I don't think we're going to get any relief from any federal government.
Okay, next question. If the tenant stopped, hold on one second. If the tenant stopped paying since December 2019 and we went to court and a judge gave them 3 more months, what will we need to do?
Well, I mean, obviously, if the judge gave him 3 more months, you're going to have to wait for that period of time. I did mention during this webinar that in addition to everything else, the sheriff at this point in time is not conducting lockouts. I do think that that will start up again in May, but right now they're not conducting lockouts. I just had a case where, same situation, where the tenant had already been adjudicated as guilty of unlawful detainer. The writ was at the sheriff's office, but of course the sheriff wasn't doing lockouts. In this particular case, the tenant lived with the landlord and his family. She did. And during this time period, knowing that she couldn't get evicted, she would go around the house, you're not going to believe this, and intentionally be coughing in the presence of other people, thinking whatever was going through her demented mind. That related to an issue dealing with health and safety. So on Friday, my team went into the Santa Monica court and got an order ordering the sheriff to effectuate the eviction, which they were successful in doing. And we've been doing a lot of these. So even if you've got a case that's stymied because you either can't file it, or you can't file a default, or you can't get a trial date, or you can't get the sheriff to throw them out, if you're dealing with health and safety, that would be a different story. So let's take, for example, a case where a tenant didn't pay the rent, lost his job, and that's the reason why he's not paying rent. And let's pretend that you have a lawsuit filed at that point in time, or even if you don't. But let's pretend the tenant is going around the complex with a gun and shooting, or some other mischief, where he's creating a serious disturbance. In that basis, you would have the right to go into court on an emergency ex parte motion, which we're doing. I'm telling you, we're doing a bunch of these, and get a court order that either the lawsuit can proceed, or that a trial date should be given, or that the sheriff should be ordered to effectuate the lockout. So again, if you're in a situation where your lawsuit was just based on extra people or based on non-payment of rent, but if the tenant is doing something else that's not safe, then you have the right to go forward with your eviction action, but you do need to have a court order to do so, and we need to go in ex parte to do so.
If a landlord wants to move back into their unit, parentheses Culver City, can they get the tenants out?
Yeah, they can get the tenants out, in a month of Sundays. So you'd have to wait again for the pandemic to be declared over, and then wait another 90 days. Then the landlord could proceed forward with that type of an eviction. Los Angeles has exempted all no-fault eviction. So again, you're selling your house, you need to get the person out, it doesn't matter. And let's pretend your tenant has plenty of money, it could go someplace else. It really makes no difference. It's not causally connected, but it makes no difference. You can't go forward with an eviction.
Is there any potential emergency order from California that will mandate mortgage companies to hold their mortgage payments instead of a forbearance program?
I don't think so. And since that would be kind of these are federal banks or national banks, I don't think the state of California would have that authority to do so. Maybe the federal government could. But again, we're pushing the can down the road. There's investors who own financial institutions too. These monies have got to be paid. If the landlord doesn't pay his mortgage payment, and let's pretend he's excused, okay? But you see, his mortgage is not going away. So in 1 year, let's pretend they gave you a 1-year buy. Eventually, you're going to have to make up that money. But if you're going to give the tenant a 1-year furlough from paying his rent, that tenant's just going to move away. This is going to be lost money for the landlord that the landlord will never recoup. And that's why I think you're going to see such an uptick in foreclosures that are being commenced through no fault of the landlord, where tenants just sat there. So forbearance on mortgage payments really is not going to be maybe some relief, but not much, because eventually someone's going to have to step up to the plate, and that payment is going to have to be made. And where is the landlord going to get the money for that if the tenants just escaped without paying?
Next question. Is the city of Burbank requiring specific forms to be sent out to tenants?
There's about 120 municipalities. I don't believe Burbank is one of them, but again, they all, and I caution whether you're, actually, I take that back. If the municipality in the county of Los Angeles has not created their own specific ordinance, the county of Los Angeles has just issued a ruling stating that if the individual municipality hasn't issued a ruling with regard to the COVID-19 pandemic and a moratorium on payment of rent, then the county kicks in, and the county's worse because it takes 1 year for the county. They're giving tenants to repay. So anywhere in LA County, landlords are behind the 8 ball. So unless it is not related to the COVID. Now here's another example that we've been doing. A client will come to us with rent that hasn't been paid since December. And a client just came to us with rent from December to April, and they want to initiate an eviction. So in that situation, I don't want to even get close to the tenant claiming, well, I lost my job, so I couldn't pay. So what we're doing is we're issuing a 3-day notice for rent from December through February only. Now, it's interesting because the lawsuit will automatically include rent for March and April and May, but we're only asking for rent from December to February. So why are we doing that? Is because the tenant would have a defense to say, hey, I didn't pay my rent because of the pandemic. But if I'm only asking for rent that became due on February 1st, there's no basis that anybody can say that the pandemic created the inability of the tenant not to pay the rent. So on that basis, we're taking in lawsuits with that, with built-in excuses that we're wiping out because we're not asking for rent payments for that period of time. And now
Okay, we got
there?
another one. We got another one, sorry.
Good.
What can we do with cases filed months ago? How can I take the default?
Well, you can't. You can't take a default, again, based on the judicial council's emergency rule that says 90 days after the pandemic is declared. But at least with regard to that one, at least you have a lawsuit on file. At least that lawsuit has a lower case number, and all you've got to do at the end of that 90-day period is file your default, and you should relatively quickly get a writ issued that you could deliver over to the sheriff's office. I would predict in about 7 to 10 days. You should check with the court to see if the tenant has in fact filed an answer, because if they have, then you'd be able to request a trial and you'll get the court quicker, as opposed to finding that out when you take the default on September 1.
Okay, we got a lot of questions, so I'm only going to take a couple more, Dennis. If the tenant contends failure to pay rent is due to COVID-19, can you still serve pay or quit and file UD so he can get in court queue early?
And the answer is no, because it's an absolute defense in all jurisdictions now that if in fact it was related to the pandemic, that would be considered a defense. So if the tenant doesn't have to pay the rent for 6 months to 1 year, if you serve a 3-day notice now, you're declaring that the rent is due now. Well, it's not due now if it was related to the pandemic. Now, of course, the tenant's going to have to prove this. And when we get to court, we're going to be serving what we call discovery on the tenant to state, let me see that you weren't working during this time. Let me see any letters that you got terminated from your employment. I would like to see how much money is in a bank account. Again, if I have a bank account where I've lost my job, but I have $300,000 in a bank account, well, you know what? I can pay the rent. Doesn't matter that I've lost my job. And there's no basis of saying that I have an inability to pay due to the COVID pandemic. So that's the situation. You really wouldn't be able to go forward and file a default until that time period is over.
Okay, one more question, Dennis. What if the tenant's lease term expires before the 12-month rent deferral period ends? Can I initiate collecting back due rent as soon as the tenant vacantism, even though it's before the 12-month after the emergency period expires?
Nothing prevents you from filing a civil lawsuit for rent that's owed now. And they'll issue a summons and you could serve them. I just think that since those cases take so long to prosecute and tend to be more expensive, that I don't think it makes sense to do that. I would go more of the unlawful detainer route. That's going to be quicker, even with this delay. It might be more intimidating on the tenant because he's going to have to step up and get himself an attorney to file a response to that summons in most situations. But again, it's a situation where I think we're just going to have to ride the storm until maybe the Judicial Council gets some common sense and gets rid of this emergency rule.
I'm actually going to ask one more question because I think it's a pretty good question. Do you recommend leasing vacant apartments right now, or is it smart to leave vacant so you don't end up with a non-paying tenant?
Well, one thing is certain, you're going to end up with a not paying tenant if the place is vacant. I guarantee you're going to make no money. So you can lease out your units. Again, the tenant the next month. I have this case in Beverly Hills where the tenant was paying for a house. Are you sitting down, ladies and gentlemen? $27,500. They paid rent for the month of January, and then by February, they're already crying that they can't pay the rent. Of course, we're proceeding forward with that case, but again, in that situation, I would still lease it out. I would make sure that you're getting at least a 2-month security, which is legal, plus the first month's rent. So that would be a total of 3 months rent upon move-in. You actually are under the law, and it's kind of a unusual case where you can get 6 months to 1 year rent in advance, not less than 6 months, but you can enter into a contract with a tenant to get a 2-month security plus advanced rent payments up to 6 months to 1 year, but not less. It's a kind of a screwy law in the state of California. So in that case, you would want to make sure that you get as much security, and it's the best you can do. Make sure that their job is not related to an industry that would be out of business. Like I wouldn't work for the head chef of a restaurant or take that person, but as to other people whose industries are not affected, if you can find one, certainly I would take that. If you guys do have any other questions, you can call our office. I've got a toll-free number. It is 1-800-77-EVICT. I know my associates who are manning the phones from their different location will be thrilled that I gave out that number, 1-800-77-EVICT, but we don't charge for a quick phone call, and if we can be of assistance to you, once again, you can check my website, evict123.com. I will have that Los Angeles notice posted probably within an hour or so, and we'll take it from there. Anthony, I want to thank you very much for the opportunity, and you guys are great.
Yeah, so on the screen right now, you can see Dennis's information if you didn't have a chance to write that down. Again, Dennis Block, an associate, 1-800-77-EVICT. And his email is also on there. Please feel free to go ahead and give him a call, as he mentioned. Again, you're dealing with the #1 eviction attorney in the state of California. So what better hands can you possibly be in? Also, we've got a couple things we want to, first of all, thank you, Dennis, for the great information.
You're very welcome.
It was absolutely great. We had about 480 people on here. Sorry about the inconvenience initially. For some reason, it wasn't allowing more than 300 on here, but we got that resolved, obviously. So we've got over 480 participants. So it's obviously a topic that is very, very interesting and people want to know about. So I think you're going to be busy for a while, Dennis. Next up, I'd like to bring Danny Carrillo with Encore Mortgage. He's going to talk a little bit for a few minutes about information on what to expect with lending in the next couple months. Okay, thanks.
Thank you, everyone. Can you guys, everybody hear me?
Yes.
Yeah, okay. So I know that a lot of you, I've seen a lot of posts out there that are saying that if you call your bank or your servicer, you're going to be able to enter into a forbearance. And that they're not going to report on your credit report and that it's not going to be affected on your FICO score. Well, I want to share something with you that I got recently. Let me see if I can share my screen. Jorge, can I share my screen? I think you need to stop sharing your screen. Okay, got it. Perfect. Thank you. So I want you to share this with you. I don't know if you can see this, but this is US Bank right here, and they're reporting a late on my client on April, and this is accounting forbearance dated and with one-time study. This client or this borrower just dropped 80 points on their FICO score, and they're in forbearance. So be careful what we're advising our buyers on what to, if they ask you, hey, can I stop making a payment? Make sure that that's the last alternative to do it, because these banks are not gonna just stay behind and they're gonna act like nothing's happening and they're gonna listen to Fannie Freddie rules. Not everybody is following Fannie and Freddie rules. In this scenario, they are reporting a 1 times late and is reporting as a forbearance. Guess what? When they come back and they want to do a refinance or they want to do anything else, they're not going to be able to because it's going to be treated as everybody else. You have a late, you're not going to qualify. So make sure that we have this information going to our buyers. Now, I want to ask you guys, if you guys are interested on valuable information, I'm part of the core training and I share a lot of information that my coaches are sharing for real estate agents. Please go to this website, write this down, partner.danielcarrillo.net. He's going to schedule a Zoom call with me for about 15 minutes, and I'm going to give you a lot of value. I'm going to give you access to a lot of training stuff that I have every single day. Tomorrow, there's a training going on how to thrive through this market. It's a really good information that we have and that you're going to like it. I always bring a lot of value to my agent partners to be able to grow together. So if there's anything that I can help you with, feel free to reach out and schedule a Zoom call on this link. It's a 15-minute, something quick. I can guarantee you that I'm not going to waste your time. It's going to be very valuable information that I can give you. Again, it's been a great call. Thank you for having me on the call. And if you have any questions, please write it down, and Anthony or myself, I can read to it. Is this a good time to refinance? Susan asks, is this a good time to refinance? Well, just so you know, the rates are super low right now. You can get around 3.25, 3.5%. So anybody that you know that has a rate over 4%, they must be refinancing right now. They're going to be off 2 months, so most likely they're not going to pay May and June. Their first payment is going to be on July. So anybody that needs to refinance is the time. Of course, they have to be working. A lot of people, they said, hey, can I refinance? It's going to be, I'm only working 1 day of the week. Of course, you're not going to qualify. The bank needs to verify the income right now. Non-owner occupied rates are prods. You can get a rate of on an investment property around 4.25, more or less. So it's a pretty good rate. The investments, they usually have like 4.5 to 4.75. What a specific date the form has to be to Central Tenants? No, that's not for me. How long before you refinance when you just bought? They need to make at least 6 payments. If they already made 6 payments from when they bought it, they are able to refinance again or drop the rate. Any other questions? Guys, thank you. Go to this link that I have. Schedule a 15-minute meeting. I can guarantee you have a lot of tools, a lot of resources that I can help you with. And let's all try through this market. It's not easy, but we're gonna all try. And any questions, I'm here to help you.
Thank you, Danny. Appreciate it. George wants to speak a little bit about some farming strategies just for a few minutes. Thank you, everyone, for staying on. Appreciate it.
It's real fast. This is quick. What's a good farming right now? Absentee owners outside of California. All these owners, they're going to be scared with all these rent control, people not paying the rent, this and that. There's a very good chance. We're seeing a lot of new open orders from sellers that they're out of state. So that's a real good farming. If you want to get those type of farming, you can use PCTTitleToolbox.com. You can. We're going to have a training next week. I'm sorry, but if you want a one-on-one with your rep or with me, just let us know. It's a great tool right now to try to get those type of farming. Any questions? Tony, what's the website for Pacific Coast Title Toolbox? Is PCT Title Toolbox. I'm going to type it to everybody. If you don't have an account, just contact your title rep. PCTTitleToolbox.com. Sorry, guys, I'm blind. No questions? Well, this is the end of the meeting. Thank you so much. Sorry for the hiccup. I'm going to have to find a lawyer to sue Zoom. We have the $2,000 account a month. And first we were blocked at 100, then they 300. Finally, at the end, it started working. So I apologize for that. Just contact your title rep if you need more information about Denny's block, if you need we can ask him to send us a video of this training. Thank you, guys. Anthony?
Thank you, everybody, for joining us. Have a great, productive Monday. Thank you.
Bye, guys.
Thank you.
Thank you very much.
Thank you.
Thank you. Have a blessed Monday and productive and stay safe.
Thank you very much.
Everyone.
Thank you. Have a nice weekend. Or not, nice week.
This is gonna be my new Facebook, my iPhone ID. I need to take a new picture with this. Crazy.
Stay safe.
I went on vacation. I was not in the States, came back, and this whole thing is driving me nuts.
What is your name again? What is your name?
I'm sorry.
What is your name?
My name is Jorge George.
Jorge George?
Jorge or George?
Jorge. I know Jorge is George in Spanish.
Correct.
Okay, what is your last name?
Mesa, M-E-S-A.
Okay. Thank you so much.
Thank you.
How do I reach you?
My phone number, 562-343-3725. My email, jmesa, M-E-S-A, at pct.com, pacificcoasttitle.com.
Thank you very kindly.
Thank you. Thank you, Cecile. Can hear you, but thank you.
Jorge, I have a question.
Yes.
How we can get a copy of the meeting in case we miss in the beginning of the meeting?
Send me your information.
Okay.
Are you Lourdes?
Yes.
Oh yeah, I sent you a message. I don't think you saw the message. Send me all your information to my email, jmesa, M-E-S-A, at pct.com. Or who's your title rep from Pacific Coast Title? You have one?
Hugo Lopez?
Contact Mr. Lopez.
Okay.
He can help you.
Okay, sounds good. Thank you. Have a nice day.
Thank you.
Hi.
Hello.
Hi, Mr. Mesa. I wanted to know, can you email me the recording of this program because I couldn't log on due to the 300 max?
No, that was Zoom. According to Zoom, there was the system crashed for a few minutes. Yeah, but yeah, at the end we were able to fix it. But yeah, no problem. You want to send me an email with all your information?
Yes, sir. It's jmesa@pct.com.
Correct. Or you can contact your title rep from Pacific Coast Title if you have one. If not, you can just send me your information.
All right, I'll do that right now. I'm actually in the process of refinancing right now with Pacific Coast Title as on my refi, so that's a good thing.
Thank you so much.
Thank you, sir.
Hi, Jorge.
Hi.
Hi, thank you so much and for this. So you do said that we'll be able to get a copy of the this lecture.
I'm waiting for Dennis to send it to me. So yes, as soon as I get it from him, I don't know if he's gonna send it directly to you guys or he's gonna send it to me. But if you send me your information, I will make sure that you get it today.
Well, I have Lou, so I'm sure Lou will help me with that. He's awesome.
He's Uncle Lou. Absolutely.
Yeah, he is. Yeah, because I was on there when the first 50, I was there like 10 minutes to, and then about a few minutes later, I got kicked off.
It was, believe me, I was going, and I'm an old guy. I don't go in a panic attack, but I was having a panic attack. It's like, what's going on?
Yeah, I got to explain to my client. Thank you so very much for your time.
Thank you. Tony, I'm still on the.
Hi, you hear me?
I can barely hear you. Are you trying to talk to me?
Yes, I am. I was just wondering, you kind of cut out a little bit, but you said this is a good time to do a refinance for
No,
commercial property?
that was the lender. I'm title, the lender, and I missed that part. I was not on the call on the conference when he said that. So if you want to send me your information, I can send you his information. So I don't do refinances.
I see. But the lender, that was Daniel Carrillo?
Correct.
Okay. Okay. All right. Thank you for setting this up. Very appreciate it.
Thank you, sir. What's up, Nelson?
Hey, how are you? Good stuff today.
Oh, I was worried this thing was not working.
Yeah, I had a few texts me, but they were able to log on, and you know, we'll get them the recording. So